from a Ford law. At a Ford law, we practice criminal and family law throughout Massachusetts. All of our fees are based on a sliding scale, which is based on your income. That means the less you make, the less you pay. Today, we want to discuss probation violations in Massachusetts. What is a probation violation? Well, first of all, if you're on probation, that's because you had a criminal case earlier. You either took it to trial and lost, or you pled out short of trial. In any case, you were placed on probation. Now, that could have been probation with a continuation without a finding, a quaff. It could be a guilty probation, or it could be a suspended sentence. In any case, you're on probation for a period of time, and you have certain conditions while you're on probation. Being on probation is not the same as not being on probation, obviously. It's called conditional liberty. Your liberty is your freedom. So that just means that you have your freedom. You're not in jail. You're not under arrest. Or you're not incarcerated. However, you're not a totally free person either. You have certain conditions that you must meet while you're on probation. So first of all, every probationer is told that they cannot get rearrested on any new charges. If you get charged with a new crime, you could very well be in a violation of your probation. Even if there are no other conditions, that condition is standard to anyone that's on probation. Secondly, there could be specific conditions that you have as a result of your plea or your sentence after trial. Typically, the most common ones are to stay away, have no contact with the alleged victim. Perhaps it's remain drug and alcohol free with random screens. Perhaps you have to attend and complete certain classes or programs, or mental health treatment, or they could be any number of things. Restitution is another one. In any case, those are specific to your case, and you have to do those things. So what happens is if your probation officer feels that you have violated any of the conditions of your probation, he or she will bring you forward before the court to answer to those charges. So if it's a new charge you've picked up, that's considered a substantive violation of probation, and if it's something other than that, it's a more technical violation, which is still a serious matter, but not quite as serious as a new picking up a new charge. So what happens is you're told to be in court on a certain day, and you will be presented as a probation violator. At that time, a probation violation hearing will be set up. It will be scheduled sometime in the future. One of the big questions at that time is going to be, are you going to be held in detention while you're waiting for that final hearing, or will you simply be released and told to return on a certain date for that violation hearing? In any case, when you come back for the violation hearing, you have the absolute right to a violation hearing, to a full hearing. And that means that the probation department has the burden of proof to show the judge, more likely than not, that you are in violation of your conditions of probation. And that standard of more likely than not is a very low standard. It's like 51% to 49%. So the judge is convinced more likely than not you did whatever the probation department is accusing you of doing, or perhaps not doing. When I say not doing, that means you've been ordered to take a class, for instance, and you haven't taken that class. So that would be an example of not doing what you're supposed to be doing. At the violation hearing, the probation officer has to put on evidence, sometimes with the help of the assistant district attorney who's in the courtroom. In any case, it's a fairly straightforward matter. Oftentimes, it's what's called on the papers. So the probation department will simply put forward any documentation that you haven't completed your program, or you're in violation. You tested positive for drugs or alcohol, or whatever the case may be. Or they could be calling witnesses, such as an arresting officer. If you did pick up a new charge, the arresting officer on the new charge is typically brought in to testify, to say, yes, that's the person that I arrested. Yes, it was the arrested for whatever it is, a breaking and entering charge, or whatever the new charge is, in order to convince the judge. Your attorney has the opportunity to cross-examine any witnesses that they bring in, has the opportunity to object to any documentary evidence coming in, if there's any grounds to do so, and your attorney has the opportunity to present a case on your behalf. You can call witnesses if you want. You can present documentary evidence or photographs or whatever it might be in your defense of your probation violation hearing, and you can testify on your own behalf if you chose to do so. But of course, you can't be forced to. That's your Fifth Amendment privilege against self-incrimination. In any case, the probation violation hearing is a two-step process. So that's the first step, is the hearing itself for the judge to determine yes or no there was a violation. Oftentimes, people don't take it to a full hearing. They waive their hearing because uh, the probation department has you dead to rights. That just means there's no feasible way that you're going to be able to disprove what the probation department is saying about you. From a tactical point of view, you also may want to waive the hearing so that they don't put on evidence and testimony in particular if the person that they're calling, their testimony would be particularly harmful to you. So let's say you picked up a new charge and it's an alleged crime of violence, a domestic violence or any kind, an assault and battery case. That person comes in and they make you out to be a terrible person, and they go into details about how they claim that you assaulted and beat them, and these are your injuries and so forth. That's going to weigh a lot heavier in the judge's mind than simply waiving your right to the hearing, just admitting that you've been charged with a new case. You're not admitting to the underlying facts, just that you've been charged with the case. So you can have a hearing or not. That's something that you need to discuss with your attorney. The second phase is, okay, now if there's no violation found, if you take it to a hearing and there's no violation found, okay, that's it. The judge doesn't go any further. That case is over. If a violation is found, the next question is going to be, okay, so what do we do about that now? What are the consequences? Some of the consequences depend on what type of sentence you're on. As I said, if you have a continuation without a finding, if you are guilty with straight probation or guilty with a suspended sentence. Sometimes if it's a minor violation and it's your first violation, oftentimes you can be continued on the same conditions of probation. The judge will admonish you, which means basically give you a stern warning that he or she is cutting you a break and not to do anything again, because the second time on a violation is going to be much more serious, and it is. And they could continue you on the same conditions. They could add conditions to your probation. They could extend your probation. Those are some of the lower ranking consequences as far as a violation goes. Worse than that, obviously, is if you have a continuation without a finding, a quaff, they can convert that quaff to a guilty. Now, if you had a quaff originally, that's not a conviction. If they convert it to a guilty, that is a conviction. Now you have a conviction on your record, and if the underlying charge that you're on probation for is a felony, now you're a convicted felon. So certainly serious consequences stem from that. If you have one of the big distinctions is if you're on a suspended sentence rather than straight probation. A suspended sentence is at the time of the sentencing, the judge says, I'm going to send you to the House of Corrections for a period of time, but I'm going to suspend that so you don't have to actually go, but you're going to be on probation, and that sentence is sort of hanging over your head for that period of probation. Now, if you're found to be in violation of your probation on a suspended sentence, and the judge is inclined to give you any time at all, any committed time, so he or she wants to send you to jail for a period of time, they have no discretion. They have to give you the full amount of the suspended time that's hanging over your head. So as an example, let's say that you're on probation on a suspended sentence and you have 1 year hanging. You pick up a new charge. You come in for your violation hearing, and a violation is found, and the judge thinks that's a pretty serious violation and your record's bad or whatever it might be. I think that person deserves to be committed for a period of time. He or she can't give you 30 days, 60 days, 6 months. They can only give you the time that you have hanging, in this example, 1 year. So a suspended sentence is very much a much more serious situation with a lot more jeopardy than a straight probation. Straight probation gives the judge a lot more discretion about what they want to do and how they want to handle the case. So probation violations, very, very important. It's very important while you're on probation to stay on the straight and narrow. Don't get any new charges. Complete whatever conditions you have. Get the case closed and behind you, and move on with your life. If you are presented as a probation violator, definitely get an attorney. It's a lot easier for the government to put you in jail as a result of a probation violation than it is on the original case, mostly because on the any new cases, the Commonwealth has the burden of proof beyond a reasonable doubt, which is a much higher standard than a preponderance of the evidence. And that's what we're talking about here, more likely than not. So at Afford Law, we do practice criminal and family law throughout Massachusetts. Our fees are all based on a sliding scale based on your income. So that means the less you make, the less you have to pay. Please feel free to visit us at affordlaw.org. We have a lot of resources there for you. While you're there, please feel free to call or book a free virtual appointment with me. I'd be happy to answer any questions you might have about your particular case, be it a criminal law case or a family law case. That's a free consultation from the comfort of your own home, thanks to our friends from Zoom. So keep in mind that at Afford Law, we're making justice affordable. Thanks very much.